I'm just curious, when I'm not sharing my video, do you still see the slideshow?
It looks like your screen is still being shared.
Okay. Got 39 people here. It's good. Or 37.
All right, do we want to give it a little bit longer, or do you think we should just get started with the intros? What do you think?
Yeah, I can start talking.
Oh, can I introduce you first?
Yeah, sure. Yeah, go right ahead. Just get going. Yeah.
It's important that I'm able to fulfill that role. Okay.
Yeah, no, it's kind of what I meant. We can just start exchanging whatever introductory comments we want here.
Okay, sounds good. Okay. Good evening. Thank you for attending People's Law School this evening. Tonight, we have Steve Sinas from the Sinas Dramis Law Firm here to talk about the new auto no-fault reform. A few introductory comments I'd like to make first. The People's Law School is brought to you by the Sinas Dramis Law Firm and Michigan Association for Justice. This year, we have a media sponsor, WLNS6. Please make sure you do join us next week for landlord-tenant foreclosure law with a special emphasis on COVID-19 and its impact on housing issues. That presentation will be by Karen Chapakis from the Grand Rapids area. My name is Jackie Dupler. I'm an attorney at the Sinas Dramis Law Firm based in Lansing. The format for this evening is we'll have our presentation by Mr. Sinas for about 1 hour, and then a question answer period for 10 or 15 minutes. I would add, you will be muted on Zoom, so none of the other participants will hear you. If you have any questions throughout the presentation, I would ask that you type that question in the chat feature on Zoom, and then Mr. Sinas will attempt to answer those throughout, and there'll also obviously be questions at the end. I'd like to introduce Mr. Sinas. Steve earned his undergraduate degree from the University of Michigan, where he double majored in economics and English literature, and earned his law degree at Wayne State University Law School. He is a partner at the Sinas Dramis Law Firm. He specializes in representing people who have been injured or harmed by the negligence or wrongdoing of another person, company, institution, or governmental entity. Additionally, he specializes in litigating against insurance companies that have wrongfully denied coverage or benefits to injured people. Steve currently serves as an adjunct professor of the Michigan No-Fault Auto Insurance Law at Michigan State University College of Law. He is involved in several organizations, including he is an executive board member of the Michigan Association for Justice, an executive board member of the Michigan Brain Injury Provider Council, an executive board member, and treasurer of the Ingham County Bar Association. He also previously served as a member of the State Bar of Michigan Character and Fitness Committee. He has received several awards in the field of plaintiff's personal injury law, including being recognized as a super lawyer by Super Lawyers Magazine and a leading lawyer. I can have everybody from afar give a welcome to Steve Sinas. We can get started.
Thank you very much, Jackie. I really don't like to hear myself talked about, and you can certainly all refer to me as Steve. Jackie is my trusted and highly respected colleague at Sinas Dramis, and I thank her for her efforts in putting together People's Law School. It's a tradition here at our firm, along with MAJ, that's the Michigan Association for Justice. And we're glad to continue the tradition, even though we're all living in different circumstances this year. So with that being
Steve, I'm sorry, I forgot to mention something. I'm going to send a link to all of the panelists in the chat feature to the newly updated brochure protecting the injured. And so I wanted to make sure that all the participants were able to hear that. I'm sending that briefly.
This is what she's talking about. I'll explain it a little bit more, but this is a resource that our firm has put out for a number of years, and we just updated it to cover the new no-fault law. And Jackie's going to send you a link to our website where you can download it for free. I just was mentioning that it's great to be able to continue this tradition of People's Law School and do it under a new format. I think that is resulting in maybe some different people attending and a wider audience across the state of Michigan. So I think we got a pretty good group tonight, and I thank you all for being involved and taking the time out of your evening so that you can learn about this important area of the law that does affect any of us who drive or uses a motor vehicle. So tonight we're going to try to get down to understanding what this new law is all about. It would be great to be in person. I don't want this to lull you to sleep, so hopefully I can present in such a way where that won't happen. Normally, if I'm in person, I will read the temperature of the room, so to speak, and see if there are questions and try to follow with the natural course of things in terms of what people are thinking about and what might be appropriate to stop the presentation and address if someone has a question or a concern. So I'm going to try to do that here tonight, and I'm going to try to watch the chat box while presenting, which sometimes doesn't always go as planned or exactly as you want it to. But I'm going to make sure I have the chat up. And if you have questions along the way, please feel free to put them in there, and I will try to address them. And if your question is not addressed during my presentation, we certainly will have time to address questions at the end. So with that being said, let me move on with the presentation. As I alluded to, the reason why this particular area of law is important to any of you is that somehow, some way, you are transporting yourself in a motor vehicle. Now, with that being said, this year we probably have transported ourselves a little bit less than we normally would have because we're not going to as many places. So that's an interesting, unexpected ripple in the area of auto accidents and the auto no-fault reforms that were passed in 2019 that nobody anticipated. But I think we all can see that these circumstances, while they may stay with us for quite some time, we're certainly going to return back to a more active lifestyle, and never are we going to completely separate ourselves from getting in a motor vehicle and the perils that can come with it. And so when I deal with auto accidents or talk to anybody about what they think their rights are in an auto accident, it's always been the case in my career, even prior to the reforms that were passed in 2019, that I would end up explaining to people realities about the system that were counterintuitive to them, or that they didn't expect, or that they somehow thought the opposite about. So in order to understand the way the law stands here in Michigan now, following the 2019 reforms, is a process of trying to understand where the law stood prior to the reforms and how those reforms modified that law. So with that being said, this presentation, which I've given in some shape or form various other times and occasions, I refer to this one as the realities of no-fault reform. And what I'm trying to do from a teaching standpoint is explain to you the basic principles that that exist under the law as it stands now, so that you all understand what your rights are if you were ever injured in an accident, and that you also understand what might be pursued against you if you were ever found to be a contributing factor or a cause of an accident. So we all need to understand these basic issues so that we can properly insure ourselves, so that we can properly address issues if they ever come up in terms of an accident, and what our rights are and what our obligations are. And so I'm hopeful that by the end of this presentation, you all will have a much better idea about where this stands, especially in the wake of the reforms. So let me first start by going back in time. I'm not going to get too detailed here, but I want to bring out this important development that occurred within Michigan's legal system with respect to auto accidents back in the early 1970s. Prior to this development, Michigan law would address auto accidents with the same type of legal doctrine that applied to any type of situation involving a personal injury. And that area of law is commonly referred to as tort law. And so maybe some of you have heard that term before. And so Michigan had tort law govern auto accidents up until 1973. And that's when Michigan implemented the Michigan no-fault law. And you might ask yourself, well, wait a minute, Steve, explain this tort law concept to me first before we move into Michigan no-fault. And I say, of course, because you can't really understand Michigan no-fault without understanding what tort law was and how it worked. And it's pretty simple from a general standpoint. And the general concept is that an injured person under a tort law system can recover their economic and non-economic damages, in other words, all their damages, from the at-fault driver. And the other side of that coin is that at-fault drivers cannot recover anything. It's a completely fault-based system. So that's what Michigan had prior to the no-fault law. The reasons why Michigan got away from a tort-based system for auto accidents is that while it might sound like it's reasonable to hold the at-fault driver responsible and to not allow at-fault drivers to recover anything, there is a societal cost, there is a burden on our healthcare economy that comes from auto accidents, and people, even though they might have made a mistake on the road, still need to be treated and they need to get better. And so when it comes down to a tort law system being the system that governs auto accidents, the criticisms that came about in Michigan and really across the nation was that the medical expense coverage depended upon fault. So those who were somehow deemed at fault didn't have medical expense coverage. It was overly litigious because you had to litigate fault. It was inefficient because you were arguing about things in court and deciding who was at fault. And in the end, auto claims burdened the healthcare economy. So we wanted a way to make sure that the extremely high cost of healthcare that comes from auto accidents is somehow better covered. So we implemented the Michigan No-Fault Act. And the central premise of the Michigan No-Fault Act is that people would receive these benefits known as no-fault benefits. And they'd get them, excuse me for a second here, sorry. And they get them from their own insurance company. I'm just checking the chat here. I just want to make sure I have it open. Excuse me for a second. And I'm going to explain to you what no-fault benefits are. But the premise of no-fault benefits is that you get them typically from your own insurance company, and they're payable regardless of fault. And so I'm going to explain to you what those benefits are, but just understand you have these benefits that are payable by showing that you've been in an accident, and they're payable to you even if perhaps you were at fault. And the claim against the at-fault driver would then be limited to a certain type of damage known as pain and suffering, and some economic loss that's not covered by no fault. And I'll get into that in a little bit here. But the grand compromise is that you were no longer going to have a system where the at-fault driver had all this liability. You're going to have a system where people bought this product known as no-fault insurance that was going to give them no-fault benefits, and that was going to be payable regardless of fault, and that we wouldn't have to sue each other for our medical coverage. So we developed a system where we had coverage, but we didn't have to sue each other to get our treatment paid for. This system that I'm talking about was not repealed by the 2019 reforms. So when you're trying to understand where the law stands, don't think that the 2019 reforms replaced the no-fault law. The no-fault law is still in existence. It just greatly modified certain aspects of that law. And to make it a little more confusing, it didn't modify other aspects of that law. And so where the law stands overall is a bit of a mishmash between where it once stood and where it now stands, especially considering that some of the changes are fundamental. It's just that the system itself still exists, and so do many of the fundamental concepts. But again, it's a mishmash of pre-existing fundamental concepts and principles and some new ones that I'm going to try to cover here tonight. So when you're trying to take this in and say, hey, he said something about no-fault benefits. What are no-fault benefits? And I want to make sure that we have a good understanding and that we can be disciplined in our thinking about what these no-fault benefits actually cover. So when I say if you're injured in an accident and you get no-fault benefits, there are certain benefits that qualify as no-fault benefits, and there are certain claims that don't. Here are the claims that qualify as no-fault benefits. The first one is known as the allowable expense benefit. And by the way, the link that Jackie has sent to you is the brochure that I held up earlier. I meant to point this out before I got rolling here, but I guess now is as good as time as any. This brochure gives a much more thorough summary of the concepts I'm covering here tonight. So as I go through this, I'll try to point out where in the brochure you could go to get more of an explanation where I can. And this topic is easy to point out. It would be in section 1, what are no-fault benefits? So if you want to read up more on the nuances of these benefits that I'm about to summarize, please check the brochure. In any event, with regard to allowable expense benefits, that might seem like a term of art, and it is. But what it's really defined as is anything that is reasonably necessary for the injured person's care, recovery, or rehabilitation of their auto injuries. So if you're talking about a certain type of product, service, or accommodation, those are the 3 words that are actually used in the statute, which almost pretty much covers anything you can think of: a service, a product, or an accommodation. Those are the 3 words the statute uses. If you can show that one of those is reasonably necessary for the care, recovery, or rehabilitation of your injuries, you have an allowable expense benefit. So that covers medical expenses, and it covers long-term therapy, and it covers nursing care, and it covers durable medical equipment. And we'll get into more of what the allowable expense benefit covers. But essentially, it's the medical expense benefit that is part of your no-fault benefits. Another no-fault benefit is known as work loss, and that is an income loss benefit that's payable if you can show that you were injured in an auto accident and that caused you to lose income from work that you would have performed. That benefit is payable for only 3 years. So if you're disabled for the rest of your work life or for many years after the accident, your work loss benefits through no fault are only going to be covered for 3 years. It's also capped at about $5,700 a month approximately right now. So if you made more than that, you could only get the statutory max. And it's calculated based on 85% of your gross income. So to step back here, I'm going to appreciate what I'm trying to really point out to you is that if you were to ask yourself, if you were in an accident and you were to ask yourself, what are my benefits? What can I get from my own insurance company? As long as you're not disqualified, the answer would be you get these no-fault benefits. It includes your medical, and you have this right to work loss that's subject to these limitations I just summarized. In addition to that, you also have the right to recover replacement service benefits. And a replacement service benefit, again, that's a term of art, but it covers basically household chores or things that would be known as an ordinary and necessary service that you used to do for yourself, like go grocery shopping or, house projects. Anything that would just kind of fall into the category of daily chores, daily tasks that you now need to have other people do for you. You can get paid from your insurance company to cover those. But here's the thing, it's limited to 3 years. And more importantly, it's only limited to $20 a day. So you don't get that much in the way of replacement services. If you were to pass away, you have a survivor's loss benefit that is a benefit that covers your contributions of economic, it says tangible things of economic value that you contributed to the household or to the dependents. That's what a survivor's loss benefit is. It basically covers what you brought in terms of income and other type of health insurance and employee benefits that pass down to the family. There's also a small benefit for funeral and burial expenses. So at this point in the presentation, I went through this slow so that we could let this sink in, that the answer to the question of what are no-fault benefits is an answer that is limited to these benefits. Anything else you can think of would be outside the realm of no-fault benefits. And these are payable regardless of fault. So you could run the red light and still get these. You could be drunk and you could still get these. You could, any other conceivable way you could have been negligent, you would still get these. So that's why you call them no-fault benefits. Importantly, these benefits were not changed in any way by the reforms, but the one way that the reforms did change the system is that it allows people to buy less than lifetime medical expense coverage for their no-fault insurance policy. And that comes in the form of a cap on allowable expenses. And we're going to talk more about that. So the reforms didn't change the definition of these benefits, but it changed how much medical expense coverage people actually have to have. And it even allows some people to opt out of that coverage altogether. The other thing I want you to make sure that you understand is that when I say these benefits are payable regardless of fault, that is true, with the exception that if you intentionally injured yourself, if you got in your car and drove off a cliff and you didn't die, but you were catastrophically injured, you would not receive no-fault benefits because that's not accidental. So the statute uses the term accidental bodily injury. If it's intentionally suffered by you as the injured person, it's not accidental. And then there are a few limited ways you can be disqualified. And I just want to cover those. And the way to think through this is that if you're in an accident, you didn't intentionally injure yourself, you're covered unless you fall under these limited categories that I'm about to summarize here. The first is somebody who is an owner or registrant of a vehicle that is uninsured and is being used at the time of the crash. So if I get in my vehicle and I don't have insurance on it and I own it and I drive down the street and I'm hit by somebody who, it's their fault, it doesn't really matter about the circumstances, but if I'm in that vehicle and I own it and it's uninsured, I don't get the no-fault benefits I just summarized. I'm disqualified. Also, those who knowingly use a stolen vehicle, if they're in a crash involving that vehicle, they're disqualified. And there are ways in which if you commit insurance fraud, either in the application that you submit to buy an insurance policy or in the claim making, you can end up being disqualified. And now the big one, this is the only addition when it comes to disqualifications under the new laws. It says that anybody who's not a resident of the state of Michigan is disqualified from no-fault benefits unless they happen to own a vehicle that's registered here in Michigan and insured here in Michigan. So just accept it to be the case now that if a person cannot show that they are a resident of Michigan, they are automatically disqualified from no-fault benefits, no matter if they're hit as a pedestrian, on a bicyclist, or on a bicycle, or on a motorcycle, or any other vehicle for that matter. They're disqualified unless they can fit that limited category of having a vehicle here that they own and insured here in Michigan. Why they did this is anyone's guess from a policy standpoint, I guess to save the insurance company or insurance industry money. But it certainly affects all our loved ones who come in the state of Michigan and travel on our roads, and they are now totally disqualified when many of them would be entitled to benefits under the original law. So moving on here, I just want to touch base with our chat. I think we're doing okay on questions. I kind of covered this already, so I don't think I need to take too much time here, but the language of this allowable expense benefit, which is the medical expense coverage under the no-fault law, states that the insurers have to pay all reasonable charges incurred for reasonably necessary product, services, and accommodations for an injured person's care, recovery, or rehabilitation. That is the definition of an allowable expense benefit. So when an insurance company wants to deny payment for a particular medical expense, they have to show that it's not reasonably necessary for the injured person's care, recovery, or rehabilitation, or that the amount being sought is not a reasonable charge. So it's a pretty expansive benefit. It's really the centerpiece of the Michigan no-fault insurance system. And frankly, as a person representing many catastrophically injured people, I can see that this benefit does a great amount of good for people's care, for people's ability to stay living in their own home with their own family, because it's such a broad benefit. It doesn't cover just the hospitalization. It covers, moving on to this next slide here, all these things: hospitalization, surgeries, nursing and attendant care, rehabilitative therapies, medical transportation, medical mileage, housing, handicap accessible accommodations, case management services, guardian expenses. So when it comes down to it, you have this comprehensive coverage for people who sustain severe brain injuries, spinal cord injuries, and who really need help in all aspects of their life. And the Michigan no-fault insurance system, because of that sentence, has been able to provide those types of people with a tremendous amount of care and resources. You should also note, from a consumer buying standpoint, that there are two different types of no-fault coverage, or there always has been two different types of no-fault coverage. The two different types consist of uncoordinated no-fault or coordinated no-fault. And uncoordinated no-fault costs more. And what you're doing there is you're elevating your no-fault insurance company to pay primary for your accident-related medical expenses. So if you are covered under an uncoordinated no-fault policy, you're injured in an accident, and if you have Blue Cross, you wouldn't turn to Blue Cross first. You turn to your own auto insurance company, and they have to pay in full and primary for your auto-related medical care. So it costs more. And then there is coordinated no-fault, and coordinated no-fault is the opposite, where if you're in an accident and you have that Blue Cross policy, Blue Cross has to pay first, auto pays second. So this obligation to go through health insurance first. Because health insurance pays first, it saves the auto carriers a lot of money, and therefore you get a slight reduction in your premium. Perhaps you should get a bigger reduction than you get, but nonetheless, you get a reduction. So this has always been a feature of the system. And following the reforms, this continues to be a feature of the system. So I'm going to get to the point where I recommend what you all should buy or continue to buy in terms of insurance coverage. And this is part of the recommendation regarding whether you should buy coordinated or uncoordinated. And I'll explain that a little bit more as we move on here. So let me get these up here and take a sip here. Just to further the knowledge base here in terms of you being able to answer simple questions about what your rights are if you were ever injured in an accident, or if you know anyone who's injured in an accident. We've established that you now know about no-fault benefits, and that they consist of specific types of benefits, that they're payable regardless of fault, and that maybe there are some ways in which you can be disqualified, but the vast amount of people are entitled to these benefits and can be entitled to these benefits even if they don't have their own policy. And I'll explain that a little bit more. But getting into that issue, you have to understand the general rule is that with regard to your no-fault benefits, you turn to your own insurance company first. But there can be exceptions to this rule. If you're on a motorcycle, say I'm on a motorcycle, say I have auto insurance with Acme Auto Insurance, and I'm on my motorcycle and Jackie hits me, the law says I turn to Jackie's no-fault policy to cover my no-fault benefits before I turn to Acme. If Jackie doesn't have insurance, then I would turn to Acme, meaning my auto insurance company. And so this is just the general rule is you turn to your own insurance company, and the general rule with regard to this exception is that you go to the vehicle involved with the motorcycle. And you should understand that motorcycles are a unique vehicle under the Michigan no-fault law. They're not motor vehicles. So a motorcyclist only gets benefits if there's a motor vehicle involved, another car. If you're on a motorcycle and you just spin out and there's not a motor vehicle who caused you to spin out or hit you or somehow caused you to swerve out of the way, there's not going to be any basis to say you're entitled to benefits because it didn't involve a motor vehicle. You were just one motorcycle. But when you do involve a motor vehicle, you turn to the policy on that vehicle first. In a similar fashion, if you are driving an employer-owned vehicle, it doesn't matter if you're in the scope of your employment or not. Say you take the company car home and you get your family in the car and you guys go to a restaurant. The rule says that the entire family receives benefits from the company that owned the vehicle or from their insurance company, not the personal insurance company of the family. That's true for the employee, but it's also true for the employee's spouse and the employee's children. So people need to understand that when they're using a company vehicle, the no-fault policy that's really at issue is the policy that the company bought, not the one they bought. The same is true when you have a situation where someone's injured in a vehicle for hire, as the law refers to it, which is where you pay money to use a vehicle. It's complicated to summarize the law here. Some of you might be wondering about ride sharing. We can talk about that later, but just understand that there are certain situations where you don't turn to your own insurance company if you are in a vehicle for hire. No-fault reform did not change these rules. So these rules stand. And so to answer the question of what insurance company pays, you say the general rule is you typically turn to your own insurance company. But if you're on a motorcycle or dealing with an employer-owned vehicle or a vehicle for hire, you might be dealing with a different policy. So if I didn't emphasize this before, I should do it right now, that the original law, and I think I alluded to this, but let me just explain it a little bit better. The original law said that everyone has to buy no-fault insurance. No-fault insurance provides no-fault benefits, as I summarize them. And with regard to the medical expense, everybody had to buy lifetime medical. So if you owned a vehicle here in Michigan and you legally insured it, whether you wanted to or not, you ended up getting a policy that provided you lifetime coverage. The reforms change that. The reforms say that we now can buy policies that have much less than lifetime coverage. And I'll explain to you the options as we move on here. And as I said before, it allows some people to opt out. And so for 40 years, any accident in Michigan, as long as there was no fault insurance coverage that would apply, everybody could know that the people who were injured had lifetime care. Now we are entering into a huge, new, brave, new world of different types of coverage and the implications that flow from that. So one reality of this brave new world is that with limited exceptions, because a person's no-fault policy covers them and anyone who lives with them who's a relative, all the people will be subject to the insurance buying decisions of that one person who buys that policy. So if you have a family, say it's me, I'm buying the policy, my kids are going to be affected by my decisions. My wife is going to be affected by my decisions. And that if I don't buy lifetime, we're all not going to get lifetime. We're all going to get whatever limited amount I end up buying. And so the reality is that lifetime is only going to be available to people if they actually buy it. And the concern is a lot of people won't buy it. Now, moving on with this issue about lifetime coverage no longer being the norm that everybody has if you're injured in an auto accident. The new norm is you get whatever you bought, and so does your family. But the new norm now that exists for people who don't have a policy is that under the original law, if you didn't buy auto insurance, say you just didn't own a car, you couldn't afford it, you then got around by foot or by bike or by bus. If you were hit by a car, even though you didn't have a policy, you were going to still be entitled to claim lifetime no-fault coverage from whatever insurance company was legally obligated to pay it to you. And that could have been in various situations, that could be a different result. It could be the insurance coverage on the vehicle that hits you. And it could also be this place called the assigned claims plan, which is part of the no-fault law. That part of the no-fault law addresses the situation where people don't have a policy to claim benefits. And that part of the law establishes this thing called the assigned claims plan. And the assigned claims plan is this, it's this entity that exists where you submit a claim saying, I don't have a policy, I'm entitled to benefits, assign my claim to an insurance company. And there are 7 or 8 insurance companies out there that are part of this plan as dictated by the law, and they get assigned the case, and then they have to pay you your benefits. So it's a strange part of the system, but it's the part of the system that deals with situations where people are injured, entitled to no-fault benefits, but there is no policy. The 2019 reforms expand upon the amount of people that have to claim benefits this way. Without getting into the details, the law says for most situations, if you don't have your own policy, you're going to the assigned claims plan. You're not going to claim off of someone else's plan or policy. You're not going to claim off of a stranger's policy just because they owned the motor vehicle that was involved in the crash. In most situations, if you don't have your own policy, you're going to end up claiming benefits through the assigned claims plan. And the kicker is that anybody who claims those benefits under the 2019 reforms is capped at $250,000. So there is a much bigger group of people who are now going to have to claim benefits this way. They no longer are going to have the lifetime coverage they would have had through the assigned claims plan, and they are then going to be capped at $250,000. So it's a little confusing aspect of the law, but that is just another way in which the lifetime coverage won't be there to service a lot of people under the reforms. There's a question here. What happens in a motorcycle versus motorcycle collision? To build upon what I was trying to explain before, if there's not a motor vehicle, meaning a vehicle that has 4 wheels, or at least more than 2, there's an actual definition of what a motor vehicle is, and it's quite complicated. But just think of it in terms of cars, SUVs, vans, trucks. All those are motor vehicles. A motorcycle is not a motor vehicle. And so if it's 2 motorcycles and they hit each other, that's 2 motorcycles that doesn't include the involvement of a motor vehicle. And so there is no-fault coverage. So the real point I'm trying to make here is just that we are going to be dealing with a system going forward where anyone's fate has been sealed by the person in their household who bought the insurance policy and the decisions they made. And all other people who aren't covered by a policy are not going to have lifetime coverage, with limited exceptions. What I want to do right now is just take the opportunity here, as I'm finishing up the no-fault benefit side of the explanation of this new system we have, is just to try to sum up what we believe to be the best recommendation regarding buying no-fault insurance coverage. And we recommend that the safest option for people is to buy unlimited, meaning lifetime medical expense coverage, uncoordinated, and non-managed care is this new feature within the system where you have to distinguish between whether you're buying a managed care plan or a non-managed care plan. And a managed care plan is something where the insurance company can basically dictate who you see as a or for your medical care, they create a network that you have to stay within. So you don't want that. You want non-managed care. You don't want to be coordinated. You want to be able to submit your bills right to your own auto insurance company, and you don't want to be capped. You want to have lifetime medical expense coverage so that if you or your family members were ever injured in a crash, you would be able to have full coverage and not have to worry about being limited in what was there to provide long-term care to your family. So moving on, if you are trying to see if you can answer these questions to the basic issues that arise following a motor vehicle accident, hopefully you can now answer the question of what is no fault and what are no fault benefits, and in general, who's going to pay you those no fault benefits. Hopefully you have a good understanding of that. But then the other side of the coin is, if there's an at-fault driver, what can you recover against the at-fault driver? And under the original law, your damages did not include medical expenses. You were pretty much legally prohibited from claiming your medical expenses from the at-fault driver because you had that coverage under no fault. You had lifetime medical expense coverage under no fault. So you didn't need to double up and also claim those expenses from the at-fault driver. And in fact, the system was supposed to be balanced between the fact that you no longer had to burden the insurance system with a tort claim that included the medical expenses in order to cover the person's medical care. You now had medical expense coverage on the no-fault side, so you want to take out that burden on the tort side so the system can exist overall. And so as consumers, we had this right to lifetime medical expense coverage, but we also had this protection that in the event we made a mistake and injured somebody, we couldn't be sued for their lifetime medical expense needs. If they would come up with a care plan saying that they need $10 million of medical care because we inadvertently rolled through a stop sign and paralyzed them, the reality for us for the last 40 years is that we couldn't be held liable for the $10 million care plan. But at the same time, we knew that they had that $10 million covered through the medical expense portion of their no-fault insurance. So the system provided for the protection without the added liability on the consumer. With that being said, the at-fault driver could be held liable for pain and suffering damages, which is compensation if your quality of life has been greatly diminished by your injuries. But those claims would be limited to only the type of injury that passes this seriousness threshold the law has in it, meaning that it says that if you're not hurt seriously, or if you're only hurt in a minor way, you don't have the pain and suffering claim. You need to either die, you need to have a permanent serious disfigurement, or you need to have what the law refers to as a serious impairment of body function. These are all terms that are defined in the statute. The bottom line is you need to be hurt pretty badly to be able to claim the pain and suffering claim against the at-fault driver. And that's always been the rule within the system, and that remains the rule under the 2019 reforms. Prior to the reforms, there was this limited right to pursue certain economic damages against the at-fault driver. And it was basically coverage for things that weren't covered by no fault. And if you try to put it all together, if you remember back to what I was talking about with the no fault benefits, there was a limitation on work loss benefits of 3 years. And that's statutory max of $5,700 a month. If you have income loss over and above those amounts or longer than 3 years, you have always had a right to pursue that excess economic loss from the at-fault driver. So if you're going to be disabled for 10 years, you'd get 3 from no fault, and you'd be able to sue the at-fault driver for the extra 7. But under the original law, that was basically it in terms of what you could recover from the at-fault driver. And while we didn't quite appreciate it, what it meant was while we were paying a good amount of money for the no-fault insurance portion of our coverage, we were paying not too much money at all for the liability insurance coverage portion of our policy. And liability insurance is what covers the claims made against us if we are negligent and hurt somebody. So because the damages were so limited that could be actually pursued against us as at-fault drivers, the insurance companies didn't have to worry as much about what their exposure was because the claims were so limited. So we're going to get into how that may change how much insurance costs overall as we talk more about the new system. And as part of that new system, the most important feature of it is that now that people can buy less than lifetime coverage, at-fault drivers can be sued for uncovered medical expenses. So as I get into the options that people can now select from in terms of how much medical expense coverage they have, understand that people can buy very small amounts of that coverage and can even opt out. And the new reality is that if they buy that type of policy and they get in their car and drive down the road and you make a mistake and hit them, they can sue you now for any uncovered medical expenses. So if they have a very small amount of medical expense coverage and you inadvertently paralyze them, you now can be sued for the $10 million care plan I was referring to before. And that's a fundamentally new reality that now exists on Michigan roads as a result of the 2019 reforms. And the policy reason behind it is that if you're going to take away the coverage that would normally be there for somebody and they've been injured by an at-fault driver, they shouldn't be without the coverage they need for their injuries. They're in a situation where they've had limited no-fault coverage apply to their claim, but the law now says, hey, you can turn to the at-fault driver to recover the uncovered amounts. And this is where let me just make this other point here on the right of the slide. It says under the reforms, if an injured person has limited no-fault coverage or if the person opts out from no-fault coverage, the at-fault driver can be sued for the injured person's past, present, or future uncovered medical expenses. So understand, it's not just the bills the person incurred at the time they might take you to a trial and try to get a judgment against you. They can come in with that care plan and forecast how much money you might owe them. And let me make the point I was going to make is that when it comes down to the reality that we face when we buy liability insurance, on your deck sheet, you may not understand this, but you buy this type of coverage called liability insurance, and there are limits. And so you buy liability insurance coverage in the amount of $100,000/$300,000. That's what you might see on your deck sheet. What that means is that if you got in your car, rolled through the stop sign, inadvertently hurt a family, each individual is going to be able to sue you and recover from your liability insurance policy of up to $100,000 for their claim. And your insurance company is limited to paying out a total of $300,000 overall for the occurrence. So if there are 4 people who are hurt, they'd have to split up the $300,000 pie, and they'd all end up getting less than $100,000. If there are 3 people that were hurt, they would each be able to claim up to $100,000. Beyond that, they have to split up the $300,000 between them based on their injuries. But the real general point I'm trying to make is that everybody has limits to their liability insurance policy. And what happens to people who are sued and get a judgment entered against them is that their insurance company pays up to those limits, but then that judgment is something that can still be pursued against you and your assets. So if the judgment comes back at $1 million and the coverage is $100,000, the insurance company pays the 100 and then says to the person, well, you got to deal with the other $900,000 on that judgment. So when we buy liability insurance coverage, we have to understand that we're buying protection, but that protection is limited. And we want to increase those limits. And now under these reforms, we want to make sure that we increase those limits because we can be sued for so much more. And here's an extension of how that's true. Not only can people sue you for their uncovered medical expenses, they can sue you under the doctrine of pure comparative negligence. And I'm not trying to get too technical with you all, but you're here in people's law school, so I think you can stomach some of these legal terms, and you're going to be that much smarter for it if you actually understand what this doctrine is all about. So under tort law, there's this idea of negligence that is the failure to use reasonable care. But if the person bringing the lawsuit also failed to use reasonable care, they can be, or it can be argued that they were comparatively negligent, meaning that they also did something wrong. In reality, the the comparative negligence argument, when met with a negligence argument, can lead to a situation where maybe a jury would say you both are at fault for 50%, 50-50. Or they could say, you know what, yeah, the plaintiff who brought the suit, he was somewhat at fault. He was maybe 20% at fault, but it's really the defendant, he's 80% at fault. So the doctrine under the through our court system here in America has evolved in such a way where allocating fault's part of what the jury does. And then the question becomes, under the law, what do you do with that allocation? And how does it translate into a liability for somebody? And under the reforms, what they've done here is that they've not only allowed people to sue each other for medical, but they've done it based on the pure comparative negligence approach. And maybe the best way of illustrating this is through this example that's on the slide here. Say Bob is determined to be 90% at fault, but Wanda is determined to be 10% at fault. Bob can sue Wanda for 10% of his lifetime uncovered medical expenses. So if his care plan is $10 million, he can still sue Wanda for $1 million, even though the circumstances might be such that he was the one who blew the stop sign. Maybe Wanda was speeding a little bit or whatever it may be, but she clearly wasn't more at fault. And she's catastrophically injured, so she needs to sue Bob for her uncovered medical expenses, but Bob can sue her for so much. So in reality, there could be these really unfortunate scenarios play out where people are suing each other with cross claims and taking out each other's right to actually meaningfully recover money from one another that actually can go to cover their medical care. All the while, we all face this new liability under these reforms. So here's the bottom line. You all need to buy more liability insurance coverage. Since you all can be sued for more damages and all this medical expense coverage that's not covered by no fault, and that it can include past, present, and future medical expenses that's payable subject to the doctrine of comparative negligence, all that means that you can be sued for a whole lot more than you could have under the original law. That means you need to buy more liability insurance. I want to just take a moment here to make sure that I make this point clear about this presentation. I'm trying to explain the law as it stands to you as consumers so that you know the answers to questions if you're ever injured in an auto accident, what your legal rights are, and what your responsibilities are and potential liabilities. The 2019 reforms changed the no-fault insurance law in so many different ways. It's impossible to summarize all of them in a presentation like this tonight. But I just want to make the point that the reforms also had many other major changes that deserve their own presentations and focus in a different format than we're in tonight here. But just let me identify what these other major areas of change are. The first one is that medical providers will be paid drastically reduced amounts pursuant to a new fee schedule that will go into effect this July. And this fee schedule is complicated, and it's hard to determine how exactly it's going to apply to the payment of auto-related medical care. But I know many medical providers and institutions that are very concerned about the fee schedule and how it's going to affect their ability to continue to treat patients. So the fee schedule is a big deal. It drastically reduced reimbursement rates, and it'll likely have a huge financial impact on medical providers. There's also this right to claim family provided attendant care as part of that reasonably necessary benefit that I was talking about regarding the allowable expense benefit coverage, where you can get paid if you're providing care to a loved one, rather than bringing in a commercial nursing company or something like that. You're providing the care. The insurance company can pay you, but there are limitations now under the reforms that say that family members or friends or anybody who actually knew the person can only be paid up to 56 hours a week of care, which is essentially 8 hours a day. So this is known as family provided attendant care, and there are significant limitations imposed on this type of care under the reforms. There's also new regulations that are passed through these reforms, and the bottom line is that these reforms implement a procedure known as utilization review, which is a process where the government and the insurance companies can work with one another on reviewing whether or not someone's care meets the standards that need to be met in order for it to be covered under the no-fault law. And there's going to be a whole lot more back and forth between the Department of Insurance and Financial Services and insurance companies and medical providers in determining what should actually be covered under the Michigan no-fault law with regard to medical care. There's also a fraud authority that is now a branch of our Attorney General's office, and it has the authority to investigate and prosecute consumer insurance fraud. It doesn't do much to go after the insurers. So those are areas within the reforms that there's a whole lot more to talk about, but we got to go on to the insurance buying options. And I think I can whip through these pretty quick and then take the rest of the night here for questions and other comments. So with regard to the insurance buying process, maybe some of you have already gone through it, but the bottom line is you will be presented with forms that give you all types of different options. And I'm going to try to quickly summarize what those options are all about. With regard to any monetary caps that you are presented with, if you're buying insurance and you're told, here's a no-fault policy with a $50,000 cap, a $250,000 cap, a $500,000 cap, where the word lifetime is used, understand that that cap or that amount of coverage that is being presented to you is with respect to the allowable expense benefit only. It's a cap on the amount of medical expense coverage under the policy. Whatever work loss benefit you may have, that replacement service benefit I was talking about, any other no-fault benefit is not subject to these caps. So you're talking about a cap on medical expense coverage, and you have these three different amounts of 50, 250, 500, and then there's still the lifetime. And then there are two groups of people that can opt out of the medical expense coverage under no fault. And then if you're buying less than lifetime, you can buy a rider to cover attendant care. That's the care I just talked about, over and above the capped amounts of your medical expense coverage. I'll go over that a little bit more as we move through the material here. And then there's also this managed care option that I already talked about, which is where your insurance company gets to dictate who you treat with. That's also something that's now part of the insurance buying process, whether you want to buy a managed care or non-managed care no-fault policy. And obviously this key point that at-fault drivers can now be sued or be held liable for an injured person's uncovered medical expense claims. That's a new feature of the system, which means we all have to buy more liability insurance. This cap that I've been talking about, as I already said, it applies to medical expense only and does not apply to these other no-fault benefits. If the cap is purchased, if a cap policy is purchased, and say, for a hypothetical, say I buy a no-fault policy with a $500,000 cap, but my wife buys a $250,000 no-fault policy for her own vehicle, and we all live together, and one of our children is injured in an auto accident. they're going to turn to their parents' policy. There are two policies in the household, mine and my wife's, but the higher cap applies. So the kid's going to be entitled to 500, not 250. And you don't stack the two. The kid's not entitled to 750. If one of the parents had lifetime, the kid would be entitled to lifetime. So if I had 500, but my wife had lifetime, the lifetime would kick in, and that would be the cap that, or the amount that the kid's entitled to claim. This just says you have to be presented with this form when you're buying insurance. The form is very complicated. So for those who have bought insurance recently, maybe you've seen this form or a variation of it. It's a whole lot of information. But if you just remember, you want to buy lifetime, uncoordinated, non-managed care, and the most amount of liability insurance coverage you can buy, it's a lot easier to get to that form. The only bad part is you might not save any money on your auto insurance, or it might cost more. You all should note, I'm sorry, let me go back here. These reforms were passed in the name of lowering our insurance rates. There is nothing in these reforms that guarantee that the total cost of an insurance policy will go down. So if you look at your insurance policy and you see that it costs whatever it costs, there's nothing in this law that says that if you buy some variation of the choice options under the new law, you're going to pay less overall. The reforms only guarantee that the portion of your policy that relates to your no-fault coverage will go down if you buy less than lifetime. So this could be a big area of disappointment for people who buy that cheaper policy that doesn't provide them as much medical expense coverage, and they see that the total amount of their policy didn't go down. And it also doesn't factor in the reality that we now have to buy more liability insurance. So if they're only bringing down the line item on our policy that deals with no-fault insurance, and that's the only thing that's guaranteed to go down by some small amount, there's no protection in the law that says that your liability insurance coverage won't go up in cost. And in fact, the insurance industry has predicted that is going to happen. Not to get too much in the weeds here, but while we're talking about rates, this is also part of consumer education, I believe. There's nothing in the law that guarantees the total cost of your insurance will go down. We've talked about that. It's only with respect to a certain line item. That's the no-fault insurance line item. And here's the other point. It's not a percentage of how much you paid for that no-fault insurance coverage. It's a percentage of what the insurance company you're buying your policy from, what that insurance company charged on average throughout the state of Michigan as of May 1st, 2019. That's the language of the statute. So some of these legislators have been out there saying, hey, just look to your insurance policy and find your line item for no fault and just take your percentage and you're going to save that amount. That is just wrong. And in fact, in areas such as like Detroit, where the cost of insurance is exorbitant, their discount is going to be the average amount that their insurance companies were charging throughout the entire state, which is presumably lower than they were charging them in Detroit. So it's going to be real interesting to see how rates are dealt with by insurance companies, how this reduction is applied. And based on the language of the statute, the reduction is not all it's cracked up to be, at least not what certain legislators have been saying about it. To illustrate all these points about deck sheets, maybe I could have showed this before, but this might bring it all together for you. I think you can see my mouse here. Personal injury protection, this is no fault. This person has full medical. That's the other term that's used for uncoordinated, meaning that their insurance company, their auto insurance company pays the full amount for their medical. And full wage. You can actually coordinate your wage loss too in the same respect. If you have disability insurance coverage and you get coordinated wage loss, they got to pay first before you get that work loss. I should have mentioned that, but this goes to show all the things that go into your insurance premium. Now, this was in Ingham County, and I think this was about a year ago, but this person wasn't paying that much. They got personal injury protection, that's no fault. MCCA, that's this other reinsurance fund that's part of no fault. So this amount is supposed to go down if you buy less than lifetime, this MCCA assessment. And this percentage reduction I'm talking about is only with respect to this amount. And this residual bodily injury, that's another term for liability insurance. Some policies call it liability, some call it residual bodily injury. Look at this, was only $68. But this is probably going to cost more because now people can be sued for uncovered medical expenses. While I'm talking about this deck sheet, I should also bring up uninsured and underinsured motorist coverage. So if I'm in my car and somebody runs a red light and hits me, say Bob hits me after running a red light and Bob doesn't have insurance, and I'm catastrophically injured and I have a big pain and suffering claim because my life is never going to be the same, and I find out that Bob has no insurance and he has no assets that I can recover if I ever bring a lawsuit against him, you might think that I have no place to turn, but I do if I have this policy here. This is uninsured motorist coverage. What I need to do is then show my insurance company that Bob didn't have insurance, and they say, okay, well, you were hit by an uninsured motorist, and now we step in the shoes of Bob and pay you up to $1 million. Same thing with underinsured. Say Bob had $20,000 of liability insurance, the state minimum. It's actually $50,000 now. It used to be 20. Under the law, they moved it up to 50. But say he had 50 and I had catastrophic injuries, I would recover 50 from Bob, and then my insurance company would step in and be liable for an additional $950 if my damages were that high. So you protect yourself when you buy uninsured and underinsured motorist coverage. So our recommendation is you keep this PIP coverage lifetime, you keep it full or uncoordinated. Same with wage. You jack up this liability insurance limits as high as it'll go, and on a personal policy, it's usually $1 million. And you can buy an additional umbrella liability policy that covers you beyond that. So if you bought the $1 million liability policy and a $2 million umbrella, you got $3 million of coverage. But you want to increase that liability because you could have more liability out there. And then you also want to further protect yourself from uninsured drivers or underinsured drivers and get this type of coverage. While we're talking about the options, I want to go back to coordination. If you were to think about buying less than lifetime, I would highly recommend that you buy coordinated PIP, a coordinated PIP choice plan, I should say. And this cap policy, PIP choice, it all means the same thing. It means you're limiting your medical expense coverage under no fault. And the reason why I would suggest that you buy coordinated is that what that's going to do is require you to access any coverage under your health insurance first. So you're going to have to deal with that obligation, but you're going to preserve that limited amount of funds that you have through no fault, whether it's $500,000 or $250,000. And you're going to preserve that so that you only use it for the things that your health insurance doesn't cover. If you bought uncoordinated PIP, then even if you had Blue Cross, you wouldn't be able to even access it because the Blue Cross plan would say your no fault's paying first. So you would use up all your $250,000 or $500,000 in no fault, and then run out of that and then be stuck with whatever Blue Cross covers, which can cover a lot. But if you're seriously hurt, it doesn't cover all that you're going to need. Some quick points about the options I've already summarized. The $50,000 option is only available to those who are on Medicaid and those who are in a household that has people who are either insured through Medicaid or another form of health insurance. And if they can't meet that criteria, then they can't buy this. There's a question in the chat that I'm going to get to in a second. I know we're over an hour. I don't see too many questions in chat. If you want to start firing them away, I'll try to get to them. I think I need about 5 more minutes to sum up the materials. The $250,000 cap option and the $500,000 cap option is available to anyone. Unlimited is available to anyone. The attendant care rider that I already referred to is if you want to, basically, if you're in a situation where you buy that limited medical expense coverage policy, And then you also want to have additional funds to cover nursing care in your home. You can cover that through this rider that is gonna cost you an additional amount of money. It's going to vary from insurer to insurer. So you might see that as one of the options your agent presents. With regard to the 250K excluder opt-out, that's not what the law refers to it as, but they don't even give it a name. Here's the general principle. If you can show that you have health insurance that does not have an auto exclusion, and a lot of health insurance policies don't, there are definitely some that do, especially those that are covered by ERISA or self-funded plans. But a typical Blue Cross plan very well might not have an auto exclusion. And if you go to buy an insurance policy through your auto insurance agent and you say, I want the $250,000 medical expense cap policy, and then the agent says, do you have health insurance that doesn't have an auto exclusion, and you somehow prove that you do, the agent can then offer you a complete opt-out altogether. And you could walk out of there with a legal no-fault insurance policy that has $0 of medical expense coverage whatsoever. And then you would be forced to use your health insurance entirely. One thing to understand is that no fault doesn't leave you with co-pays and deductibles like health insurance does. It really covers all your expenses if it works the right way. Managed care, I talked about that. I think this is a real dangerous thing to get involved with, because the insurance companies determine who your doctors are, and they get to write the rules and the policy about how your claims need to be pursued, and you don't want to be stuck with that. But it allows the insurance companies to offer you managed care options. You might be enticed by them because of the way they're sold to you and the fact that they cost less. They do have to cost less than a non-managed care option. But my point to you is that if you are thinking about what types of auto insurance options you may want to select, you would never select a managed care option, and run for the hills if your agent's trying to sell it to you. Keep your liberty to treat with who you want to treat with, and keep your rights as established under the law intact, and don't buy one of these policies that effectively changes all that for you. So again, the safest option is for people to buy unlimited, uncoordinated, non-managed care, no-fault medical expense coverage. And then the other side of this reality here is that you all need to buy more liability insurance coverage. You don't know who you're going to hit. No accident is planned, obviously. None of my clients were planning to be injured. And on the flip side, most of the defendants weren't planning on hurting somebody. And then they got to deal with it. But now, for the first time in almost 50 years, we're all getting in our cars here, knowing that if we get in an accident and the person we hit is somebody who opts out, doesn't have no-fault insurance coverage at all, then they can sue us for every single dollar related to their auto-related injuries. The other point that I should have had a slide on, and maybe I skipped over it real quick there. If you're on Medicare, you can opt out of no fault too. If you can show that you have a coverage through Medicare, and people in your household either have Medicare or coverage that would cover them if they're in an auto accident through health insurance or another form of auto insurance. So people on Medicare can also get that same type of opt-out. And what I was referring to about being sued is that if you hit somebody who's an opt-outer, whether they're the 250K opt-outer I was talking about or the Medicare person, they all can sue you for $1, the ambulance bill, the hospitalization, anything related to their injuries, they can sue you for, past, present, and future. All right. I talked about uninsured and underinsured. So I'm going to go by this slide here and get to the questions. Okay, so One question is, if I don't own a vehicle and walk to and from work or ride my bike, should I consider buying a no-fault policy to cover my expenses? That's a very interesting question. Let me take the opportunity in answering it to try to apply what I was hoping to establish through the presentation tonight, but I know there is a lot of concepts here. So this is a great question to try to tie it together. So the general rule is that if you're hit by a car, you're walking down the road, say you're pedestrian, the general rule is you turn to your own insurance company. If you don't have your own policy, you then look to the people you live with. And if any of them are your relatives, meaning not just friends, but they're actually related to you, or you're married to them as a spouse, then you would see if they have a policy. And if they don't have a policy, then you're in a household that doesn't have a policy at all. And for the most part, you're going to end up at the assigned claims plan. And the assigned claims plan is going to randomly assign your case to an insurance company who then takes over your case. And the thing is that your expenses are going to be capped at $250,000 if that's the case. So if you're not seriously hurt, it's not going to be an issue. But if you were somebody who was walking a lot and had the chance of being hit as a pedestrian, usually when you're hit as a pedestrian, you could be injured pretty severely, and you face the prospect of lifetime medical care, the only way you're going to get that is by buying a no-fault policy. But the practical issue you're going to face is that if you don't have your own car, you don't have a car to buy a no-fault policy for. So you might need to buy like a junker or something like that if you were to really want to go to the length of fully protecting yourself as a pedestrian or as a cyclist. So if you have your own vehicles, you're going to buy auto insurance, and if you follow a recommendation, you'll buy the lifetime coverage. This won't be an issue. But if you don't own a vehicle and you're not in a household that has one, I would recommend that you try to get the lifetime coverage, but you're going to have that issue of not having a vehicle to actually insure. We have another question is, what if the ERISA SPD of your health insurance says auto must be primary, auto secondary? So this is a really good question. I would tread with great caution for anybody who has an ERISA plan and is considering to do anything other than lifetime no-fault medical expense coverage. ERISA plans are governed by federal law, and they have great power within them to take away money you might pursue in a tort case for your uncovered medical expenses. And with respect to whether you could even opt out with an ERISA plan will depend upon the actual language. And that opt-out capability that I was talking about in terms of showing that you don't have an auto exclusion, ERISA policies in particular have a lot of auto exclusions. So I think that any agent out there that really does their due diligence in looking at people's policy, if they see it's an ERISA policy, they're going to want to know more. And it's likely going to be the case that that person is not going to qualify for an opt-out because there is going to be an exclusion, such as the one the question is asking about. The other question here is, did the auto reform insurance changes this year change the way that residency is determined for a child that just graduated from college and is applying to grad school and still living in temporary housing in another town? The answer to that question is no. Residency is, there's an analysis that's been set forth in case law, and it's pretty established under case law. It's not something that was changed in the no-fault law itself. This is also an opportunity to tie in some of these fundamental principles. You turn to your own policy or the policy of your spouse or a resident relative. The key is if the person is a relative but is not a resident of your same household, they technically don't have a right to claim under your policy. I see this happen all the time where kids, refer to mom and dad's house as their permanent place of residence, but they live in a different town with the idea that, they're only temporarily there. So they're just still claiming that they're covered under their parents' auto policy. Really, you're getting yourself into dangerous territory with that. I mean, I know it's real tempting to do that, and people naturally do it. But when you find yourself in that situation, you shouldn't let it go on very long. you can do a couple things. You could try to get your child added as an additional driver. But in doing so, you need to be totally upfront in disclosing where they live. You do not want to misrepresent the fact that your child, doesn't really live in your house, so that when you actually need the policy, they go back to your application and see that they're going to say you lied. And if they are able to show that you misrepresented anything, and you need the coverage later on because of an accident, they can just cancel your policy right then and there and not pay you anything. So you don't want to mess around with how you represent where your kids live. And the only way to get them properly covered is to get them added as an additional driver. And when you do that, you should just be explicit about the reality of how they may be staying at your house but not actually living there, and see what the agent says. And my additional advice there is you probably want to put that down into writing. And in this day and age, email is used so often that hopefully you can email with your agent, and you should just lay it all out there. Be as truthful as you can be, and take the premium as it may come to you and your family. And that way you don't have that incredibly difficult and disappointing situation where you really need the coverage, but they say to you, well, you lied to us a long time ago and we just found out now, but that means we don't have to pay you anything. And I've had that happen many times. Not too many, but enough where I don't want to see it happen again. Somebody told me that I answered their question. They asked a question, they said question answered, so I'm happy about that. Think I have addressed the questions in the chat. People can feel free to chime in with questions over the speaker if they'd like. Until there's another question, I will just try to summarize some various concepts that we've talked about. One is the MCCA. Why don't I talk about that for a little bit? That might be interesting to people. I don't have a slide on it. I'm just going to stop sharing my screen here. You don't need to. So the MCCA, you may have remembered on my deck sheet, there was that line item for it, and maybe you've heard about it. But the way it works is that it's a fund of money that really allows for there to be the lifetime coverage that exists here in our auto no-fault insurance system. So let me try to explain it through a hypothetical. Say I'm catastrophically injured and I rack up hundreds of thousands of dollars of medical bills. I get to the point where I exceed $600,000 of medical expenses and counting. I'm still treating. Depending on when my accident occurred, the monetary threshold that kicks in for the MCCA involvement is around $550,000. I think it's about 570 right now. I'd have to go back and verify. They keep on fluctuating based on year to year, and they adjust it for a number of things. But it's right under $600,000. So once my medical expenses exceed that amount, the reality of what's really going on is that my auto insurance company pays my medical expenses. They have paid my medical expenses up to that amount. They continue to pay for them, but the amounts paid over and above that amount get reimbursed to them by the Michigan Catastrophic Claims Association, which is funded by all of us in the form of the assessment fee that we pay every time we pay our insurance premiums. And the amount that I showed on my deck sheet is the amount that I had to pay at the time. No, that wasn't mine. I'm sorry. That really was not my deck sheet. That was someone else's deck sheet, but that was the person that was the amount the person had to pay at the time. And every 6 months, we all pay a good amount of money into the MCCA. And the MCCA now has over $20 billion. And that's the real source of the coverage for people who need lifetime medical care that costs millions and millions of dollars. And so we pay into it. And the MCCA is this entity that's been created by the statute. And it has a board of directors And the reforms changed how the board exactly is established and how it's made up. But when it comes down to it, the insurance companies get to control the MCCA by in large part. And the Department of Insurance and Financial Services also has a seat on the board. And they are the ones that determine how that fund operates and how it's used to reimburse the insurance companies that are paying for the catastrophic lifelong care needs of people in the system. So this money is all there. It's being managed largely by insurance companies with some oversight by government. And under these new reforms, we have so many people now who are no longer going to access that coverage because they are going to be limited to the capped PIP choice plan that they buy for their family. So if you buy the $50,000 option, you all are going to have $50,000 available if you're injured in an auto accident, but none of you are going to get to that amount that triggers the MCCA threshold. Same thing for the $250,000 plans and the $500,000 plans. So there's all these people and the opt-outers. There are all these people out there who are going to be injured and are never going to have to or never going to be able to turn to the MCCA. So over time, the MCCA is going to pay out a whole lot less money than it has been. And there's an interesting question that, as far as I know, remains unresolved. And it's who gets that money if there's extra money left in the system. If there's $20 billion in the system making all this interest, and it's going to stay in the system because it's not all going to be used up. They say it might be used up, but say it's not, where does it go? And it'll be real interesting if we get to that point in time, how that pans out, because one would think it should go back to the people and not to the insurance companies. But some say they're concerned that the insurance companies will try to keep it for themselves and not redistribute it back to the people. So I'm not trying to stir the pot here. I'm just trying to say this issue kind of got lost amidst the debate that went into the 2019 reforms. And hopefully people keep track of it so that there is a fair result that ends up happening through time, so that the people get some benefit for the money that they actually paid into the system and created this fund that now exists. I'm just looking here to see if we have any more questions here. The other thing that oh, you know what? I see. I apologize. There's another, I was looking at two different parts. I was getting questions from two different aspects of Zoom here. So let me get to some of these questions. Okay, there are several questions about umbrella policies. So let me go back and make sure we understand how this works. When we buy auto insurance, we buy a policy that has various types of coverages, as I explained in the deck sheet. And one of those line items of coverage covers our mistakes if we actually hit somebody and hurt them. And it's known as liability insurance coverage or residual bodily injury coverage. We have limits that we buy of that coverage that our auto insurance company has to pay up to. Beyond those limits, if we don't buy an additional umbrella policy, our assets could be pursued if a judgment was entered against us over and above our limits. So we buy umbrella policies to cover that extra amount that we might be facing in terms of financial exposure. I think if you have any significant amount of assets, you should at least buy a $2 million umbrella, and it doesn't cost that much more to increase it to 5. And under this new law, because there's this right that lawyers will definitely pursue on behalf of catastrophically injured people, I think you need to fully protect yourself. So I would say $1 million on the liability, at least $2 million on the umbrella, and then $5 million if you can pay that extra amount and just get it all as high as it'll go. I don't think you can go much beyond 5 million for a personal umbrella. Maybe if you find the right company, but I think it's hard to find beyond 5 million. Someone asked, how is the assigned claims plan funded? Let me take the opportunity to explain the assigned claims plan one more time. It's that entity that exists where we have situations where people are injured and they don't have a policy to turn to. And the law now increases the number of people who are going to be going to that plan because they no longer claim benefits through other people's policies like they did under the old law. So it's a strange reality that's being addressed through the assigned claims plan, but it's effectively funded through our insurance rates. There's a portion of the rate that we actually pay to our company that goes to help fund and operate the assigned claims plan. So it's kind of factored into our rates, is how I understand it. And there's some other funding that the insurance companies pay into it as well, directly from their funds. Someone asked, how does it work with Medicare? I think I skipped over my Medicare slide, but I tried to go back and make sure I explained it. If you're on Medicare and you're in a household where, say, just you and your spouse and you both are on Medicare, you can go in and buy auto insurance that has no medical expense coverage at all. And then you are faced to just use Medicare. And I can tell you, representing many elderly people who've been seriously injured in an auto accident, Medicare does not fully cover your needs. Medicare is a source of coverage that will certainly cover your hospitalization and your medical expenses, in terms of your frontline medical care, but it doesn't cover long-term commercial nursing care. It doesn't cover long-term therapies. It doesn't cover residential accommodations if you're brain injured and you can no longer live at home. So when it comes down to it, Michigan no-fault insurance coverage has done a lot for those who are seriously injured and elderly. And I have a big concern for people who opt out of the system now, as they're allowed to do when they're seriously injured in an auto accident and they have limited financial means or they're on a fixed income, and they realize that their Medicare coverage, while it pays for a lot of things, doesn't pay for what they really need, or at least not what they need over the longer future. And so the law allows them to do this, and I would counsel anyone on Medicare to not go for it. I mean, I know you probably are enticed by the option because it's going to save you a lot of money, but it's not real coverage. The other part about it too, not to get too detailed here, but if you are an opt-outer and you don't have no-fault insurance coverage, you might think, well, I have my Medicare, I have my health insurance. But if you go ahead and have them pay, and then you try to pursue the at-fault driver, if there is one, and make a recovery there that benefits you in some financial way, they can claim a lien on it. Medicare can come in and say, you know what, we paid for your hospitalization, we paid for your lien. So all that money that was going to go to you for your compensation, for your pain and suffering, is actually going to go to us to pay us back for the medical expenses that we paid for you and your injuries. And so when you opt out, it's not opting out without a price. There is a price, there is a consequence that you will face somehow, some way from that decision if you're ever injured. We have a Facebook Live question. Do you have a rider to claim attendant care if you have limited PIP, or can you claim it against the 250K or 500K? It's a good question. When I give this presentation, I feel like I'm going through so many details that I don't want to lose you all, but let me try to answer this question and reinforce how this attendant care rider works. Say I buy the 250K medical expense coverage, I get injured, I go through that coverage. I'm hospitalized, I have a surgery, need some therapy, I reach my max, I can no longer claim benefits through that plan anymore because I reach my max. But I paid for an attendant care rider as a separate part of my insurance buying decisions. And in doing that, what I've done is I've created a fund that can fund my nursing care in home, even though I've exhausted my medical expense coverage. Now, the question is, how much will insurance companies sell for that rider? And the answer to that is not entirely clear right now. I've seen some companies selling them for various increments, 10, 20, 30, 40, $50,000 I've heard. We shall see how much they actually offer. But it's basically like a special fund to cover care in the home. And you should note that there's nothing about that that allows you to circumvent the family provided attendant care. So if you think you're going to buy the attendant care rider as a way of not dealing with that 56-hour-a-week limitation, you're going to be sorely mistaken. You're still going to have to deal with that. And so if you want to exceed that 56-hour-a-week payment limitation, you're going to need to hire strangers, people who don't know you. I can also take a minute here, if you don't mind, to explain the fact that my law firm, in a case that I'm not primarily handling, but I'm certainly involved with, and other great attorneys in my firm are doing the real heavy lifting on, but we have a case in which we are challenging the constitutionality of these reforms. And one of the major issues we're trying to address in the case is that with regard to all these changes in the law about government regulation in terms of this these new set of rules that applies to the payment of benefits, the limitations on family provided attendant care, the limitations on reimbursement rates for medical providers, all those changes are based on the way the law is written, are intended to apply to people already in the system who were able to claim benefits based on policies that were sold with premiums that were calculated based on the old rules. So if you're injured in an accident 10 years ago and you've been claiming benefits under the system, you were getting those benefits through a policy that was issued way as to people who are recently injured. And we're saying this violates the Michigan Constitution with respect to a law that infringes upon a contract between two private parties. And so we have a couple of plaintiffs in that case who are arguing that the implementation of these new rules cannot be enforced against them because they were people already in the system who are claiming benefits based on policies sold under the old rules. And it'd be unconstitutional to change their rules as they vested under that contract that they purchased long ago and that was paying them benefits before these reforms were passed. There are other issues that we're claiming in that case as well. It's pending in the Ingham County Circuit Court, and the court is actually probably going to rule sometime soon on a number of important legal matters in that case. It likely will go up to the appellate courts where it will then also be addressed up there as well. So these reforms were not passed without controversy, and firms like ours are trying to find or what we assess the law and determine that there are various ways where there are meritorious and viable legal arguments that they are unconstitutional. We may not prevail. We hope that we do. But it goes to show that this law and its future is greatly up in the air. Somebody asked, for an elderly couple that still owns a vehicle and has an insurance policy but no longer drives, do they need to buy any additional liability insurance coverage since they will never be the at-fault driver? Well, that's true. The less you drive, the less chances are that you're going to make a mistake and hurt somebody. But I can tell you can never predict when you're going to hurt somebody. And maybe there's even an argument that if you don't drive that much, maybe when you drive, you're not going to be as good of a driver as you were when you drove more. So, there's no crystal ball you can look into. I will tell you that increasing your liability insurance limits shouldn't cost you all that much money. It may cost a little more than it did in the past because of the increased exposure the insurance companies now face. But I would look into increasing your liability insurance coverage if you ever were going to get in your vehicle and drive for any significant period of time, especially if you're elderly and maybe on a fixed income. I'm really concerned about the people who are on a fixed income, and if they do make a mistake and hurt somebody and that person doesn't have much coverage and they can sue them for so much medical expenses, then that person and their limited liability insurance policy might not be enough, and that person may find themselves in a very tough financial predicament at a terrible time in their life. So in terms of, their ability to overcome it and their retirement plan. So I would highly suggest that you continue to try to investigate how much it would cost to buy more liability insurance. Oh yeah, here's another good question. I should have seen it. It was much higher up here on the list. What is the policy if you rent a car in Michigan and get in a car accident, but you have auto no-fault insurance for a registered vehicle of your own? Okay, so let me just make this point, that our no-fault insurance coverage follows us wherever we go and applies to any injury we sustain in an automobile accident that occurs in the United States, Canada, and that's it. So it follows us anywhere in the US, the territories of the US, so you can actually get it when you're in Puerto Rico, if you're in an accident in Puerto Rico, and Canada. It doesn't apply if you're in Mexico or anywhere else in the world, or it's limited to the United States and Canada. But if you are injured in an auto accident, whether it be in your own car, in a rental vehicle, walking as a pedestrian, on a bicycle, you're likely going to be able to claim no-fault benefits under your own policy. So wherever you travel, your no-fault policy should apply. So if you had your own no-fault policy and you rented a vehicle in Michigan, you would still claim no-fault benefits from your own policy. The same would be true if you rented a vehicle down in Florida. You lived in Michigan and you went to Florida for spring break and you rented a vehicle and you're injured in an accident in Florida, your no-fault policy is going to follow you and apply to your injuries, even though it occurred down in Florida, even though you weren't in a vehicle that was insured under your own policy. That's all just part of the reality of how the law is written. I think I covered most of the questions. Let me make sure. I guess there was another one here in the other box. How much liability insurance would be considered adequate as a minimum? 1 million. I think I answered that. Most personal policies won't let you buy more than 1 million. If you want more than 1 million, you have to get an umbrella. Another question, I have unlimited coverage. If I cause a catastrophic injury to a lesser insured via an MVA, what is my exposure? Could I be sued for their excess medical? Yes. So let me take this opportunity to reinforce this concept. The recommendation for buying lifetime coverage is so that you can make sure that you have your bills covered. Now, if you bought less than lifetime and you're hit by somebody who has a $5 million, liability insurance policy, $1 million and a $5 million umbrella, so a total of $6 million, then you might have an ability there to get all your medical expense claims covered through that claim against that at-fault driver. But the reality is a lot of at-fault drivers don't have enough insurance. So the way you ensure that you will always have your medical needs covered is by buying lifetime no fault and not relying on there being that liability claim. Because many drivers out there, who make a mistake, also make the mistake of buying far too little of liability insurance coverage. So you still want to buy the lifetime. And then the reason why you want to buy more liability is so that if you happen to hit somebody who doesn't buy lifetime, because there are going to be a lot of people who do that they can't take your assets for their uncovered medical expenses. So there's a reality under these reforms. It's kind of ironic because they were passed in the name of choice, that consumers need to have choice. But we don't choose what other people buy, but we face the consequence of what they buy. If everybody bought lifetime, we wouldn't have to worry about there being this exposure to pay for people's lifetime medical care if we somehow cause the crash. But people aren't going to do that. And so now we have to factor that into what we end up buying for ourselves because of what other people are choosing. Well, I can tell you that our firm is fully committed to making sure people understand this law. You know, I don't think it's any secret that we aren't that supportive of it. And we actually tried to advocate for different changes to the system to make it work better. But our mission right now is to go about this state and educate people on it, to make sure that people know what they're doing when they buy insurance, so they make the right choices when they buy that insurance, to make sure that people understand that when it comes down to there being changes made to our no-fault insurance system, perhaps some of those changes are going to help the system, but there's certainly some signs for concern. And so my prediction is that this system is still going to be complicated and chaotic, and we're going to need to continue to make changes to it. And the best way for our state to make the most informed changes is for the people to make sure that they understand this system and that they can educate those around them so that they make the right choices for themselves and their families, but also so they can advocate to make our leaders and legislators make sure that they fix the changes or fix the aspects of the law that need to be fixed and continue to be open-minded about whether this is the right kind of system for us going forward. So I appreciate all of you being here. I feel like I talked so long and I'm sorry for that, but hopefully you all got something out of it. You can email me at stevesinas@sinasdramis.com. That's STEVESINAS@sinasdramis.com. You can also reach out to Jackie or anyone else involved with People's Law School if you have questions, and definitely download our brochure. I kind of got away from that, but I just wanted to have a conversation with you all tonight. And if you want to reinforce the concepts, please definitely look at that brochure. It gives a much more thorough summary of all these issues that we talked about tonight and more.
Thank you very much, Steve, and thank you to everyone for attending. Hopefully we can see you back here next week for our discussion on landlord-tenant foreclosure issues and COVID-19. Everybody take care and thank you again.